Let's see what's going on with the legal defense for the three I guess women who are very retarded.
Let's get into it right now with Hassan versus Orbiters. Okay. Okay.
The Orbiters. The Battle of the Orbiters.
Right? I'm going to whip out my PP here, guys. And by the way, make sure you smash the like button. Regardless of how you feel about the PP, make sure you smash the like button. It's very, very important. And also consider sharing this out on social media because it'll help us get going here as we race towards 2,000 subs. So we're in a continuation of Klein versus the Orbiters. As you guys all know, Ethan Klein is still engaged in a copyright infringement lawsuit.
Yeah.
Not defamation.
Yeah, no defamation.
Not defamation, not, criminal, whatever. This is a copyright infringement lawsuit against Casey Trons, Denim, and Frogan. Now, we're not going to talk about
no criminality, just copyright.
Because Frogi Yogi got a delay of game, and Frogi Yogi has a different lawyer. So these two ladies have the same lawyer, which is going to be...
Thank you.
Which is going to
they have the same
conflict.
They're going to have the same basically the same word for word.
This is going to be a conflict of interest without a doubt between Casey Tron and Denim's having the same attorney because they can make adverse statements against each other, so that's potentially problematic.
Yeah,
right?
they can't. Yeah, they can't. Yeah, that'd be bad.
The settlement for one could involve selling out.
Oh, I'm blocking him.
So
I'm sorry.
I think their lawyer has a conflict, but somehow magically that lawyer agreed to this, and both of these girls agreed to this, which is very, very insane.
Yeah, that's crazy. I don't know why you would do that.
These two girls,
because if they ever make disparaging comments about each other, that could hurt their case.
Initial legal paperwork, and they wrote back. They said, "Here's how we respond." And what I want you to understand when we look at this, their defense, is that Denim's filed her answer on the 14th and Casey Tron filed on the 15th. So this is something that happened just a couple days ago. Right?
Oh, what?
So it's very fresh legally. Almost nobody has covered this. Certainly people haven't read it in detail. And what I did was I read the entire document, both of them. And I looked at what they had in common, and I wanted to present the defenses they have in common. Now, just so you understand,
basically, yeah, since they're using the same lawyer, they're probably going to use the same basis of everything. Yeah, that doesn't sound good. Which talks about the paragraphs in the complaint, and they go paragraph by paragraph, and they say, we agree with this paragraph, we disagree with this paragraph, or we don't have enough knowledge to agree or disagree, and we cannot say, right? Or it's a legal conclusion, and we cannot say, because it's a legal conclusion. So that part that talks about whether they agree, disagree, or whether they don't know about the entire complaint, which is very long, and they go paragraph by paragraph, that part is boring as hell. And to read through that is like reading paint drying. So we're not going to do that. What we're going to talk about is the second part of the answer, could eat the
where
paint.
They go into what's called
you could eat the paint
affirmative
chips.
defenses.
Would it be better?
So these are the defenses.
I mean, huffing gas might help you
to
too.
Ethan Klein's lawsuit. And an affirmative defense means even if Ethan Klein is right, I'm going to get away with it because X. So we're going to score all of those. I'm going to explain to you the law. I'm going to explain to you what each of those defenses
explain
is.
it to me, lawman.
Saying and what Casey Tron is saying. I'm going to explain to you which one it is. We're going to score them.
Explain it to me like I don't know anything.
Or whether there is cope with every
I think there's 100% copium. I'm just going to say it now. I think there's 100% copium.
It is not in the favor. It is not in the favor of Denims and Casey Tron. It does not look good. But I'm going to tell you one by one, is it hope or is it cope? So let's get into it. And so
even I think Frogan's
specific responses are very generic,
all
mostly
these people
non-committal
are
denials, but the affirmative defenses are interesting. So we're going to focus on what's interesting because I don't like doing boring. And I'll show you, for example, this is the Denims complaint, right? I'll show you what I mean by boring.
Well, I mean, then again, actually, I shouldn't say that because you never know how judges rule. They could always do some weird
right here
fucketry, right? Fuckery.
Here's the beginning of the document of the answer. Alexander Marwer Saber, aka Denims. And then they go line by line, paragraph by paragraph, saying, Paragraph 1 contains legal conclusions to which no response is required. Defendant denies the allegations in paragraph 2. Paragraph 3, defendant lacks sufficient knowledge. Paragraph 4, defendant denies. Legal conclusions, lacks knowledge. Admits. So once again, in 10, they admit that. So you'd have to go back there and say, okay, what did they say? By the way, usually the only thing they admit is their name and where they live. Typically, that's it. Typically, they don't admit anything else other than their name. And that's all. That's what they'll agree to. Yeah. So what we're going to go through...
Wait, so they want to use the court system, but they want to remain anonymous?
What we're going to scroll down is all these affirmative
That's not how that works.
Which are down here. So
you're a grown-ass adult, too.
Fair use doctrine, express license, implied license, unclean hands, waiver, estoppel, justification and excuse, consent, innocent infringement, no injury and damages, good faith, inequitable conduct, unjust enrichment, latches, failure to register copyright, lack of notice, reservation of additional damages. So we're going to talk more. The reservation we're not going to talk about because that's kind of a catch-all. But all the rest of them, we're going to go through and I'm going to score those. And for some of these, ladies and gentlemen, for some of these defenses, I genuinely believe their lawyer may have been high. I'm not kidding. I don't know what.
Oh no, their lawyer was cracked out. Oh man, that's unfortunate.
But I do think that their lawyer could have been ingesting cannabis at that time. Now I'm not saying it's negligent.
Well, aren't some lawyers all alcoholics?
Creative.
So I mean, he might have been he might have been drinking some booze. You know what I'm saying? You know.
I looked at that and I actually had to look up some of the defenses because they just pulled them out of nowhere. And literally, there are certain defenses.
So they pulled it out their ass. Is what you're saying
in this area of law. I'm going to say that again because I think you need to process this. Some of these defenses don't even exist for copyright infringement. It's as if this lawyer doesn't have a lot of experience in copyright infringement, or he wants to try some crazy stuff and he's just throwing spaghetti at the wall and he sees what sticks. I'm not saying he's committing malpractice or he's not competent.
He's committing fully.
It's very creative. We're going to use that.
I mean, the fact that he like listed out all of them, right?
That's all. So let's get into the
he's throwing shit at the wall, man.
Boop, let me continue to go. First, failure to state a claim. Okay, so this is the first of the affirmative defenses. So the first affirmative defense is failure to state a claim. What failure to state a claim is it says even if all the facts are true, in a complaint, they do not establish a valid legal cause of action. This is saying they're going to be able to remove this on a motion to dismiss. Are they going to be able to argue that there is no claim here? This is an extremely weak argument. Yes, you can make the argument. It's not an impermissible or impossible argument, but it's extremely weak, and the likelihood of success is cope. The likelihood of success is cope for the affirmative defense.
I mean, that seals the deal, right? It's over. That's all she wrote.
Going to win on motion to dismiss. It's just not going to happen. Next is fair use. Now, this is their strongest of all defenses.
Well, yeah, they have to.
10, which is the most I'm going to give for any of the affirmative defenses.
Because, yeah, I mean, given what's going on, this is their only defense they can use.
Material falls under the fair use
and even then, I don't even know if they could fucking...
This is a 5 out of 10.
I don't know if they can even argue for this, given those three fucking buffoons.
If you really had to say, okay, in terms of arguments, because my strength of argument means, is this a killer argument? Is it like totally a winner?
I don't know. You still have to argue for it.
Or do they not? I think it's a toss-up.
Yeah, I mean,
some facts that they may be able to argue.
Yeah, maybe. But I mean, given what they've already said, right? I mean, they've already incriminated themselves. That's the other thing. Right? Well, I don't want to say incriminate, but they've already made some statements where it's just like probably should have not made that statement.
They have one other. Which maybe you could argue, but it's not as strong as fair use. It's not as strong as fair use. So I think it's a toss-up in Klein's favor. Okay, next, express license. What this means
license? License? You got a license for that?
Give Casey Tron and Denims permission expressly to write it. So a plaintiff cannot claim infringement against a defendant who uses plaintiff's copyrighted work if the plaintiff granted the defendant an express license to
for
use
YouTubers,
the
that's not really a...
You can use this.
It's not really a license, right?
Then you've got no express license, especially if you put that in writing. You put that in writing. I think this is a weak argument because there is no... And the likelihood of success is unlikely because there's no written or specific license. There's nowhere.
I wouldn't expect that because it's like that don't make sense. License for what? You don't get licenses in YouTubing and making videos and shit.
There's implied license. This is different. This is different. This is a little bit better. This is the second best defense.
What is this one? Permission to use something copyright material that is not explicitly granted in writing, but is inferred from the so basically.
So you could argue
or
about permission. Once again,
like
the defense is permission to use something copyrighted material.
Basically, like using articles, right, in your papers or writings
from the conduct of the owner,
and then
or the so
works cited and putting them as where you got your source or whatever.
Once again, I'm trying to be fair,
or something like that.
And I'm trying not to be.
But obviously,
that's
it's not really a license either, right?
Ethan Klein did at some point make a general statement about how he treats people using his content. However, he did not say, "I give you permission to take the entire video with minimal content," and he also did not say, "I give you permission to maliciously redirect traffic."
Correct.
So I think it's going to be difficult to argue that.
Right, however, in a sense, he could come after me because I covered his video, and
than it is.
But I don't think he would because I don't.
So this might be.
I mean, what's in it for him?
Once again, I give this at best,
I don't even
30 or 40% shot. And
I think my video is more favorable for him too.
Me being very generous for a 30 or 4% shot, versus it's a toss-up, maybe like a 45% chance on fair use because you never really know which way it goes. I think 65% in favor of Ethan, 45% on the other way because you really never know. This one's more like 20, 30%. Right. Much slower. Yeah, he definitely. So an express license means in writing. He never gave them writing or an email or something like that. Implied means the conduct, meaning, oh, hey, we're all streamers. We're all streamers. Every streamer copies somebody. No. In fact, and if you look at the overall environment, streamers strike each other all the time. Streamers strike each other over petty stuff, over stuff that's clearly
the
fair
stupidest
use.
things.
All the time. So it's not streamer culture to do this. Unclean hands. I love unclean. Yeah,
I just got striked today
Your
too.
Hands are unclean. Go wash them. Go wash.
It was like a minute. It was like a minute of their video, and they were like, "No, we don't like it."
Badly, in the specific situation they're suing about, so they cannot ask the court. So by asserting unclean hands, both Casey Tron and Denims are saying that Ethan Klein did something naughty, and therefore he can't sue.
What does that mean?
Him setting a copyright trap is unclean hands.
That doesn't make any sense.
It's not illegal.
Yeah, that's what.
Or dirty, or not practical. Many people register their copyright. In fact, that's what you should do. In fact, you're encouraged to register your copyrighted material. So this seems like a very, very weak argument.
Right, I could, for me, I could, in a sense, if they're taking, if they're trying to paint me in a bad light and ruin my reputation, I could come at them for defamation, right?
For waiver, what this
if
says
they
is
clip something out of context for me or some shit,
relevant to their claim.
No, that would be defamation claim, though. This is a copyright claim.
Relevant to the claim. He hasn't waived anything. He hasn't waived anything at all. In fact, he's
waiver claim. Oh my goodness.
So by arguing waiver, Casey Nitroms and their lawyer are just making this up. I don't see where this is coming from at all.
Yeah, well, I wonder why they. It's surprising they listed. Honestly, why didn't they just list the ones that they were more that they have more of a winning chance on? Why did they list like all the one, like everyone?
3.5. But estoppel is a concept which prevents a plaintiff from asserting a legal claim that contradicts their prior actions or statements, particularly if it would be unfair to the defendant. So it's sort of like an implied license. You could say, okay, because of the conduct of Ethan Klein in the past and the implied license, there's sort of like an estoppel here that should come out. I still think it's unlikely. 20% would be very generous. 20-30% would be generous with this one. So I think this one, yes, you can argue it. Yes, it's better than it's a hell of a lot better than waiver. I mean, waiver's a joke. Waiver's embarrassing. Waiver's like, what are you doing here? But estoppel, okay, I see it. It's not honestly, if it's anything, remember, guys,
like all the ones that are below 5 are just that you shouldn't even try. Even 5 is just like
never. You still have to try, and if they tell you to throw the kitchen sink in them, you do that.
Well, yeah.
Okay, this is a.
I mean, I would look if you didn't have a 5,
so defendant
or a 6, and your next best option was to use the 4, right? The fourth best thing.
Justify or excuse.
I mean, that's what you got to do, man.
This a 3 out of 10 was really because I looked through the entire thing and I give them so many 1s and 0s. I had to try to give them some 3s because I wanted to be fair.
I had to give them some. No, dude.
What is the justification?
What do you mean 3? I don't think, dude. Most of these I think are just like 1s and 2s. To be honest, I'm surprised you even went to like the 3, like 3s and 4s.
So
I mean, the only one that I could see even worth using is fair use, right?
Implied license or estoppel and justification or excuse is a part of that, but I just don't.
And you put that at a 5.
Sub 10% chance here. So this was a pity 3. This was a pity 3. It really should be a 2. Honestly, it should be a 2. But I gave it a pity 3. Okay, consent. This is sort of like implied license as well. So they admit.
But yeah, he didn't give. Well, I mean, but he posted it on public.
Action. So once again, just kind of sort of like justification.
Also, streamers, a lot of people without consent, right? Look at people's videos and then pick apart and take some content ideas or whatever.
Chance at most, likelihood of success.
So it's like, is there really any consent there?
Very weak. Innocent infringement. Oh, it's cute. It's an innocent infringement. It's a cute infringement. It's a type of infringement you can bring home to grandma, right? Right? No. Innocent infringement. It actually, in a weird way, I give it a 4 out of 10 because it's not actually a full defense. So what innocent infringement is it means it can reduce the damages that the court awards on a copyright infringement case. It is not a complete defense to liability.
Yeah, if this is not a defense, why are you using it? Right, you're looking for defense. Get this shit out of here.
That is possible. The judge can do that. So they could say, okay, it is infringement.
This is secondary. This has no right being here. I'm sorry, legal mind. What are you doing?
I think it's arguable. I think it's unlikely to make the
it's only defenses,
0,
sir.
But I think it's arguable. It is arguable.
This is not a defense.
So I'm okay with that. Inequitable conduct. So there is a defense in patent law. Remember, this is copyright law. Copyright law is not patent law. Okay? So their lawyer is literally using an argument
about patent law for copyright. That doesn't. Yeah, what?
That a patent applicant misrepresents or omits material information with the intent to deceive the Patent and Trademark Office. This is literally a non-existent argument, which is impossible.
Patent it.
Which only applies for patents, not copyright.
So everyone patent your content.
Thing that I've seen in a while.
Patent the schematics of the blueprint of your content. Do it.
And he does it multiple times. This is one time. He does it another time too, which is like, it blows my mind. Maybe he's trying to make a unique argument and saying, even though this exists in patent law, you judge, I want you in this case to make this up. But
let me allow.
Is this usually only applies
you
to patent
allow
office? So
me to allow you to allow me to do
office?
this?
I don't think so, and it's properly registered. So what proof do you have of that? That's what's funny there. Okay, unjust enrichment. One party was unfairly benefited at the expense of another party without proper compensation. This is hilarious.
What? I mean,
the only people that were unfairly benefited were the orbiters, Caseytron and Denos, right?
Their self-esteem and reputation.
The orbiters.
Right.
It was not Ethan Klein. How did Ethan Klein unfairly benefit? It makes no sense whatsoever. Where did his money come? Where did any money come from him? He didn't make anything. This is maximum copium. Saying that Ethan Klein was unjustly enriched. What are you talking about? Latches. The defendant.
Wow, I'm surprised there's a 0.5.
That the delay unfairly harms the defendant. This one is another one that is so brain dead. This is completely brain dead. It's near impossible.
This defendant can argue that the plaintiff waited too long to sue. Wait, what? And this delay unfairly harms the defendant. Wait,
this
what?
Is what they're arguing, guys. They are arguing that Ethan waited too long to sue. Ladies and gentlemen, he literally sued immediately. He literally sued like
if
days
they
after
actually
the
tried to argue some of these, I really want to see their opening statements to these. Holy shit, man. Some of these are just way fucking bad.
They're trying to argue he waited too long. That's their argument. It's fully within the statute of limitations. Like, fully within the statute of limitations. This argument, it's like, you're clearly just throwing this out there. Which, once again, I need to make this clear. The lawyer is not doing anything illegal. He is entitled.
He's to
make these defenses.
True.
But I'm also entitled
to say, it's not gonna win.
Absolute doggy doo. Because they are doggy doo doo. A big steaming pile, not just a little Chihuahua pile. It's a Great Dane-sized pile of doggy.
I'm surprised he's even grasping.
Let's just continue to
why didn't he just choose the more acceptable ones? Why is he grasping at straws, man?
This one I had to put it at 0. So they make the affirmative defense that while registration isn't required for copyright protection exists.
What is this gonna show the judge that you're very astute and you're very methodical and very educated? What? This doesn't mean shit, man.
How they registered it, and they give proof of registration. It is literally impossible. The copyright was clearly registered properly. It was done by a lawyer. It was done in the proper way. There is no way this argument wins. It's a 0.
Failure to register copyright.
You have all the proof of proper registration.
No, you didn't. So,
once again, I think he just
didn't file it correctly.
Or just threw everything at the wall. But this is going to be absolutely.
Your copyright is fake. It's frivolous. It's not real. You don't have the right information. It's not real.
Known about the lawsuit, therefore it should not be held liable. This is one I wanted to give another 0 as well. How are you going to be answering a lawsuit? So you've already answered the lawsuit.
Yes.
And you're saying you have no notice.
No notice, but you've answered the lawsuit.
What are you talking about?
Yeah.
You know the lawsuit's happening, and you have
that's a good one.
Notice, etc. You had notice of the copyright, etc. So
that's a really good one.
Where is this lack of notice coming from? I don't understand this one. Complete cope, and typically, this is another one that lack of notice is typically only used for premises liability. So, for example, this one typically works. For example, if you walk onto somebody's property and they have an alligator pit and they fall in the alligator pit. So if I, as a Florida man, if I build in my Florida man house, in Kissimmee,
the alligator moat,
I build an alligator pit.
No, the gator moat, don't get
some leaves, and you fall in the alligator pit. And I didn't tell you there's an alligator pit, but I invited you over. You'd say, hey, I had lack of notice. Right? I had no idea that was there. Or if there's something I should have told you about, right? For example, let's say I had a bunch of plants that were really made of super brittle glass that if you touch the plant, they would shatter in a million pieces. And you touch the plant, it shatters, and I sue you.
No.
And you could say, well, I have lack of notice. You should have notified me not to touch the plant. So let's continue with the rest of the defense.
How dare you sue me, Mr. Lawyer, sir?
So
that's not nice of you.
Not going to happen. It's cope. Failure to register, cope, impossible. Latches, cope. Unjust enrichment, cope.
Honestly, always
inequitable conduct.
Anything below 5 is cope.
Good faith, cope.
I'm sorry.
No
anything below 5 is cope.
Innocent infringement, unlikely. Consent, unlikely. Justification, excuse, unlikely. Estoppel, unlikely.
I mean, they're all excuses, to be honest.
Implied license,
most of these are excuses.
Express license, unlikely.
Fair
use, the only
is literally the only one.
You can see without a doubt, objectively, as I go through that.
And even then, it's still flimsy for them.
Cope. It is
especially with their statements and whatnot.
Where this is something that I would say, okay, this is something.
And we don't even know about the like, what are they gonna put up for discovery, even if they do this, right? It's like, what?
I think they gotta stick to fair use as their core defense and focus on that. All the time on this other stuff, really not worth it.
All right, there you have it. That is the legal mindset on the legal defenses they have. If you want to check out Legal Mindset, go take a look at his stuff, right? He's got a bunch of other stuff too. Give him like and subscribe, you know. Crazy how their best argument is actually fair use doctrine, but at the same time they completely violate all 4 pillars of it. Yeah. Yeah, that's what I was thinking too. Like if they honestly, yeah, because with their discovery, right? Like what is? I don't think they have anything. Because they've made so many statements where they just shot themselves in the foot. The only one winning in the Orbiter side is their lawyer winning fat stacks by just writing bullshit. I mean, he's getting paid to do something, right? I mean, it ain't bullshit if he's trying, right? The Denim's defense is basically, yeah, I did it, but I don't feel bad because it's so bad about it, so how can it be illegal? Yeah, I honestly, that would be Hassan's defense too. I don't think their lawyer was high. I think they begged Casey and Dennis to settle, but they were too pig-headed to take their advice. It could be. You never know. I bet Froggy is going for a bench trial. She doesn't want a jury watching her talk about wanting a 9/11 cake in her. Say soldier deserves PTSD. Oh yeah, that would be bad. That'd be bad. I mean, regardless, I think no matter if you got judge or jury, the statements they made throughout their time, it's not good. Well, actually, one of them didn't even make any statements, right? They were just smoking all the fucking time. What was that? Fucking stupid ass Casey. That's fucking. What a dumb bitch. Anyways, there you have it. If I was a lawyer and 2 of my simultaneous clients has easily accessible video evidence of the crime, yeah. Admitted they did the crime in the same yeah. Explain the motive why they did the crime. Deleted evidence shortly after finding out they're getting sued, yeah. I'd probably do the same thing because the fuck am I supposed to do with these 2? Literally did everything they could to take their fucking shit. Oh man. Anyways, there you have it. They fucked up their whole case. That's on them. Well, that's Legal Mindset. Give them a like and subscribe. See ya.